Okay, let's get started. This is 2023 CV382839. It is Jeffrey and Gail Williams versus the City of Atlanta. Can I have the appearances, please, for the Williamses?
Jeffrey Williams, appearing representing myself in this case.
Okay.
Gail Williams.
Hello, Williamses. Thank you for being here.
Thank you.
And on behalf of the city.
Good morning, Your Honor. Tracy Hackett, senior attorney with the City of Atlanta Department of Law, appearing on behalf of the City of Atlanta.
Great. And who do you have with you?
My name is Spencer Peck, also attorney with the City of Atlanta. I represent the Department of Watershed Management.
Okay.
And also at the table, we have James Bibbs, who will be city's witness.
Okay. Last name is?
Bibbs, B-I-B-B-S.
Got it. All right. Well, welcome, everyone. Let me give you a summary of what I think brings us all together. I'm not making any factual findings now. I'm just trying to streamline things for you all, because if you think I understand certain things, you don't need to cover them. But if I've got it wrong, I'm happy to be corrected. I just find this eases the process forward if I share with you what I understand the case to be about. The Williamses live on 2nd Avenue and have owned their home there for many years. For a while, you all rented it out, but then you came back after touring the world and lived there. And in 2022 on into 2023, so late 22, sort of around October, your water bills went nuts. You routinely had water bills of somewhere around $100 plus or minus $150, but what I'd call an average water bill. I'd like your water bill. I'd like to have your water bill, but it was nothing out of the ordinary. And then for 4 months in a row, it was more than 10 times what it had normally been. And it sounds like the record is you weren't installing a pool then or running a water park. It wasn't Whitewater 2 in your backyard. You had several plumbers come check it out. Neither plumber found substantive material issues with your plumbing system. Maybe there was some leak, but it wasn't a material one. More critically, one plumber said, the water meter's not working. I'm gonna run it for a little while, 5 gallons, and the water meter said something far more than 5 gallons. And then it stopped, meaning the problem stopped, not that the water stopped. The water bills reverted back to $150 a month.
87, 84.
Whatever it is. And you're back to where you thought it would be. You challenged these 4 months. Sewer and water, or the city, whatever the first tier would be, said, nope, you've got to pay it. The Williamses appealed to an entity I'd never heard of before, which is the Water and Sewer Appeals Board, which is made up of 5 citizens. 3-2, you all lost, and you are entitled to, and you did timely appeal to Superior Court, which is the natural next destination, the ruling of the WSAB that you, the Williamses, remain liable for those 4 months of out of the ordinary water usage and corresponding water bills. And here we are. So that's my understanding of the situation. The Williamses have the burden here as the appellants. So you're going to let me know why you think I ought to reverse the WSAB's decision. And then Ms. Hackett will let me know why that decision should be affirmed. And we'll see how it flows. This is a formal proceeding. So you'll need to follow the rules of evidence or whatever other rules that Ms. Hackett might seek to enforce. The fact that the Williamses are pro se doesn't mean that we dispense with the rules that would apply to a bench trial, which is what this effectively is, this appeal. But I will also be cognizant of the fact that you aren't right now practicing attorneys. You might both be lawyers, but my understanding is whatever you used to do, you stopped doing it, you traveled the world, and now you're just trying to enjoy your home without an extra $12,000 in water bills or whatever the figure is. So let me start before we dive into whatever presentation you all have, Williams's, and then we hear from the city, what, if anything, you want to correct about my overview? What if there's something that I got backwards that actually you're happy with the bills or whatever the situation is?
No, it was just one step prior to the appeal. We filed an adjustment request, which pursuant to watershed's process. When we initially got the bills and got the plumbers to come out, we filed an adjustment request requesting them to adjust our bill, and that was denied.
Okay.
And then that's when we filed an appeal.
Got it. Ms. Hackett, anything you want to adjust as to what I've provided as, again, a non-factual, as in not my factual findings, but from my review of the record below, sort of what brings us together?
No, Your Honor, that's fine for now.
Okay. I have a procedural question for you, and then I'll hear from either of the Williamses if they want to chime in. I've not had an appeal from the WSAB, and I wasn't provided with any ordinance background that would show whether this is a de novo proceeding, because you mentioned you've got a witness. Normally, when I'm handling appeals from a zoning decision or any other local government decision, what we talk about at this level would simply be, did the record below support the findings of whatever the final decision maker is, here the WSAB, and it's not time for new evidence. And so I'm curious if you can point to something that would establish this as a de novo proceeding where it would be appropriate for me to introduce into the record upon which I would rely, for example, Mr. Bibbs's testimony.
Your Honor, you're correct. And we did have some new evidence that was discovered after we submitted the record that we wanted to bring to the courts. It's a factual information that we discovered. So I'm not sure at what point, but not to retry the case, but just to bring forth the new evidence that we discovered as part of our investigation.
Okay, and what would the basis be for me to consider new evidence? I appreciate that it's newly discovered, but that sort of doesn't matter whether you had it before or you came out after it later. The WSAB, the board, let's just call it the board. The board didn't have that information. And so I would be reweighing the evidence and adding some evidence if I were to factor in what you wanted to introduce through Mr. Bibbs.
That's correct, Your Honor. However, it doesn't change the board's determination. It just goes more to the explanation as to what occurred during that time period that was not brought forth by the plaintiffs.
When you say during that time period, meaning the 4 months at issue,
Your Honor,
or during the hearing?
The 4 months at issue.
Okay. Wasn't that the city's obligation to, I don't know how it works in front of the board. Was there an advocate for the city in front of the board, or was it basically just the Williamses looking at these 5 people who were saying, why aren't you paying your bill?
No, Your Honor, it's actually the burden is on the applicant, the homeowner, to provide a basis upon which an adjustment should be granted. Right. And not the city. Okay. So to the extent that I could probably question the plaintiffs, I may not need this witness. But to the extent that it may not come out during their testimony, then I would have my witness to just respond.
Okay, but if you agree with me that this is not a de novo proceeding, and de novo would just mean we start all over again, and there's like someone would have to take the stand and say, I own this house, and there used to be small water bills, and the big ones, and we called these plumbers, etc. I don't think that's what this proceeding is. It is, you all can point to the record that was made, what's in there, what's not in there, conflicts in the testimony, whatever it is. And I am reviewing it to see if there was a sufficient factual basis to sustain the factual findings of the board. And then I'm also reviewing it to see if there were any clear legal errors. And I think those are the 2 spaces in which I get to operate. And if you agree that that's the standard of review, then I think all I get to hear from the Williams is not any testimony, but they're going to argue why either there wasn't a sufficient factual basis for the board's decision, or what legal errors, if any, they contend the board made in reaching its decision. And then the same, of course, would apply to your representation of the city in this situation. If you think there's a reason why I could consider evidence. It seems like it would be all evidence and then it would be de novo. And I may need to reset this so that both sides know, oh, I didn't realize we could bring in either new evidence or the same evidence. I don't think that's the standard we've got here. And you seem to agree with me.
I agree with that, Your Honor. I just was concerned because of your resuscitation of the facts. It seems that there was a major omission made, but we can just say, because we did not have that information prior to the hearing, we can just proceed as you suggested.
Okay, got it. And I want to be very clear. If you feel like I omitted something in my recitation of the record below, that's the kind of thing you should definitely bring to my attention. Hey, on page 32 of the transcript, here was when we introduced a photograph of this geyser in the backyard of the Williams' house. No wonder their water bill went up. I wasn't intentionally omitting anything. I was.
That's understood, Your Honor. I don't think you had it before you.
Okay, all right. Mr. Williams and Ms. Williams, do you agree that the nature of today's hearing is an argument about, it's really more legal argument about whether the decision below was properly founded on a factual record and whether there were any legal errors made, as opposed to, hey, let's call the next witness?
I agree with you, Your Honor.
Okay.
It should be based on just what was done at the appeals, no new evidence.
Okay, I think that's the right answer. I just wanted to give both sides a chance to say, no, look at this ordinance. This city ordinance says, should there be an appeal from the board, it is a de novo proceeding in front of the Superior Court. The default is that it is not. Appeals from municipal body decisions, be they zoning or whatever bills, et cetera, challenges to tax assessments are not de novo unless there is a carve out from the local authority. And I didn't have that in front of me. And the reason why I started with Ms. Hackett is she's the subject matter expert, I believe, in the how Atlanta legal process works. But given that we all agree, the two sides and the judge, that this is a more limited appellate review, then I'm going to ask you, Mr. Williams, or you, Ms. Williams, and I'm fine having one of you speak on behalf of both. But Ms. Williams, you should understand that you'll have an independent opportunity to speak because Mr. Williams technically doesn't represent you. And so you're free to say what he said, and that's all you need to say. But you are separate plaintiffs, and Mr. Williams is not your attorney at law or your attorney in fact. So when he's done, I'll ask you if there's anything you want to add. You don't have to add anything at all, but do know that you'll have that opportunity. Okay. And given that we don't have a court reporter, I'm fine having you all stay seated if you want to. You're welcome to come to the podium. I am, as long as I can hear you, and I've heard all of you just fine, you're welcome to stay right where you are, but I defer to you.
Thank you. Your Honor, I have something, I want to clear up something. At the hearing, you were asking who was there, just the 5 board members and us. If you look at page 2 of the transcript, it shows you everybody who was there. There were 3 representatives from the Department of Watershed Management, and Spencer Peck, an attorney with the city of Atlanta, was also present. They were sitting over to the right together. The board was in front of us, and then we were at a lectern. Mr. Bibbs actually was present as well. So I just want to make sure it was clear that it was Watershed Management was represented.
Okay. So tell me, Mr. Williams, why you think I should disturb any part of the board's ruling.
Before we get to that, Your Honor, I wanted to make a correction or a typo in the petition, paragraph 8.
This is in your petition?
Yes.
All right, let me pull it up. Hold on one second. Is the screen in front of you on now? The larger one?
Yes, it is.
Okay, not the one on the podium, but the one, excellent, okay. Better late than never. All right, I've got your petition, and on which page?
Paragraph 8, page 3.
Got it. Okay.
The second line, the months in question for when our bill dropped down was not January, February, March. It was February, March, and April. Okay.
And that's in the record below. I'm assuming your bills were good morning.
Yes.
Hold on one second. They somehow did. It's in. But he had to show up. I don't know why. Like I tried doing it. Deputy Gordon tried to turn it on, and so you can fix it. Thank you. Appreciate it. Okay, noted.
I had another issue or question. When you said it's gonna be a bench decision, does that mean you can rule today or at some point in the future?
No, what I meant to say, I may have misspoken, is that this is a bench trial. It's a hearing. Calling it a trial is really probably not the right term. I don't often wear the appellate hat. Mostly when I'm dealing with things, we're about to bring in a jury and it's a trial like you would see on TV, and people stand objection and their witnesses testifying. But superior courts do have a limited appellate role. If there is a challenge from magistrate court or local government decisions can be appealed, and they typically go to superior court. So the hat or robe that I'm wearing today is of the appellate sort. So this is a better way to put it would be this is oral argument. And so I just called it a bench trial because there's no jury in here. I will not be here and now when you guys are done saying, hand them $10,000 back or hand them $10,000 plus interest. I'm going to want to take it under advisement. In particular, go through the record again to make sure I'm comfortable that either it was supported factually, the board's decision, or if I think there were deficiencies, I need to be able to identify those. I don't intend to have a ruling that was similar to the board's, which was no. I mean, that was their final order, was effectively no, which makes it a little hard for a reviewing court to assess upon what they based their decision. What we typically see when handling appeals is a final decision that has some explanation behind it. Because if the board had said, we deny this appeal because A, B, C, D, and E, one, that gives you something to say, E is ridiculous. That's not even in the record. Or conversely, and typically the case, it gives Ms. Hackett a chance to say, look at A through E. There's evidence, Judge. You can't touch this now because it's really an any evidence standard. You may not like the decision that the board made, but if there is evidence supporting it, it's not the role of the appellate tribunal to disturb that decision. And so then there needs to have been legal error. But the decision we have here was a little more cryptic. I mean, it was clear, the answer, but there wasn't a lot of explanatory detail.
Another thing I wanted to raise, because I'm not familiar with this process here. I prepared a brief that I was going to read to you because I thought that you may make a decision today. But if you're not, I can submit it to you if you prefer that.
So what I'd like you to do is share with me the reasons why you think the decision should be overturned or sent back. I have three options. I can affirm and things move exactly as the board said. I can say, try again and send it back with directions. I wouldn't simply say, try again. I'd say, you need to, for example, issue a ruling that specifies why you're denying and addresses A, B, C, and D. And then they'll revisit it and they may decide to make the very same decision, or based on my direction, they may say, you know what, now that we've thought about it more, we issue a different ruling. And you guys are going to split the difference, or we rule in favor of the Williamses. The third option is I reverse it and say Williamses win. I obviously know which one you want, but those are my options. I base them on the argument that you make, the argument that Ms. Hackett makes. So if you want to read something to me, that's fine. If you want to have it be more extemporaneous, that's fine. I may interrupt you while you're reading because I may have questions about what you're saying. If you're going to submit a brief, I need to give Ms. Hackett the opportunity to do the same, just so that we have a balanced approach to this. And she might not right now have something ready to hand me. And so I'd give her time. She'd say, I need X weeks to do it. And I'd say, you bet, as long as X is a single digit number, less than 3. But I'd give her time to submit something as well. And then I'd make my ruling based on the arguments you all made today and whatever was in the briefs that you submitted. And I'm happy to work it in whatever way both sides agree on. And if there's disagreement, then I'll make one decision from the bench and it will be, here's how we're moving forward so that I can make a fully informed decision on your appeal. Does that make sense?
Yes, Your Honor. The only reason I'm raising this is because I did a summary of the case, so it would be short, so you would be here all day on this. And then the brief is only like, I think it's like 13 or 14 pages.
I don't want you to read that.
You do not.
I do not want you to read me 13 or 14 pages. I'd love for you to, in your presentation, give your highlights, and you're welcome to I'm not trying to make you give a extemporaneous speech on your toes. That's not my point. But if your plan was to come in here and read 13 pages, my thought would be, say, Judge, I'm submitting my argument in writing, and you don't need to read it. I'll make it part of the record. We're not making an oral record anyway. You all decided not to have a court reporter here. And so the record would be made through any briefs that were submitted, and I'd make sure they get e-filed. In fact, I'd probably direct both sides to e-file their briefs.
So I would not give this to you today.
You could give it to me, but then I'd also have you e-file it. So I would like to leave today with a copy of your brief,
Yes.
but you need to e-file it because then Ms. Hackett gets a copy and it's in the record. You handing it to me means that it's in my hands. But I want it to be in the record, like your petition. Your petition is in the record because you e-filed it. And I would like your brief to be of record, and that would be you e-filing it.
Just for clarification, when you say e-file, I would do the same thing I did with the petition. I would take the brief over to the clerk's office.
However you did the petition, you're gonna do the same thing.
Okay.
And there are different ways to do it. Some folks have an account and you can do it from your house. Other folks like visiting the clerk's office and they go to the little kiosk and they do it that way. I'm indifferent. I just need it in the record because that protects you. It empowers Ms. Hackett to say, here's this in the record and whatnot. But I would like to now hear what you have to say about the situation, and you're welcome to rely on your brief. But if what your plan was to simply read it into the record, let's not do that because I can read it myself and I'll get just as much from it if you allow me to do that.
At this point, Your Honor, petitioners would like to make I think this is probably a motion for summary judgment.
Okay, so a motion for summary judgment really doesn't fit where we are. My thought is this: you can put any label you want on it, but really what you should be focused on is why it is you think I should reverse and rule in your favor or send it back with directions. Because I don't think you want, like we discussed and you smiled, you don't want option 3, which is I affirm. I say, board, you got it right. So what you should do now is tell me why you think I ought to do one of those two things. Rule in your favor or send it back with directions. Don't worry about what you call it. It's not a motion for summary judgment. I don't want you to get hung up on the labels.
Well, I'm calling it a motion for summary judgment because it doesn't have anything to do with the appeals court decision. It's on the basis that the city or respondent did not file an answer in this case. Okay,
that can be part of your argument today, but we don't do summary judgment at the appellate level. That's not how it works, but that's okay. That doesn't mean you can't make the argument. You may say, here's one reason why you should rule in our favor, and here's another. And one of them, it sounds like, is very technical because you are saying the city failed to do something. And if you've got law that says failure to do that means I win, you can say, read the case of Williams versus McBurney, and I'll read that case. And you may not have case law, but you may just say, look, as a principle of fundamental fairness, and I'll consider that as well. But why don't you tell me the reason or reasons why you think today's hearing ought to end with a ruling in your favor and what that ruling would be.
Okay. Good morning, Your Honor. I'm going to start with my argument about respondent not filing an answer. Your Honor, on August 21st, 2023, an answer was filed in this case to the petition that was filed by plaintiffs, petitioners on July 18, 2023. On November 13th, 2023, Your Honor, senior staff attorney Monica Niles sent an email to Ms. Hackett asking who the August 21st answer was filed on behalf of. And Ms. Hackett responded that it was filed on behalf of Watershed Management. So then when subsequently, when the court dismissed respondent's motion to dismiss our case, the respondent was given 30 days to file an answer, which they did not do. Your order was on December 18th, which gave them to January 18th to file an answer. Therefore, since the initial brief was filed on behalf of Watershed Management, not the City of Atlanta, and no brief was filed pursuant to your dismissal of their motion to dismiss, our position is that the respondent has not filed an answer in this case. Now, I know, let's see, I don't have any case law on this, but let me see. But it just seems in fairness that if an answer is not filed, then that means that all the allegations, everything contained in the petition is deemed to be true and admitted. And therefore, then we would ask for a motion for summary judgment, although you've told me now that you can't do that.
Well, it's not a can't. Again, you can frame it any way you want. You could say, I want a motion for absolute crushing victory.
Yes.
And you could call your motion that. And I'd say, okay, that's not really a motion, but I understand what you want. What you're describing is akin to what we would call, if this were, if the original lawsuit was Williams versus the City of Atlanta, not down below, but you just came into court and you sued the City of Atlanta and they never answered. It would be what we call a default judgment. You would win by default because as long as you had served the defendant and they didn't answer, it is what you described, where it's then every allegation in the complaint is deemed admitted. We're operating in a different atmosphere because it's an appeal. Yes, you filed a lawsuit in Superior Court, but it's an appeal. And so I'm going to give in a little while Ms. Hackett a chance to respond to say, one, you should deem the answer and then the amended answer as being on behalf of the city. And maybe that's persuasive, maybe it's not. She also may say, you know what, there's no such thing as defaulting on an appeal. We're here for oral argument, and it might have been helpful if we had filed an answer because it would frame the city's response to your concerns. But I don't know. Like I said, I'm not ruling from the bench. I'll need to research what happens if there is no answer. And I'm not finding that there's no answer because I'll note that, and you noted there was an answer, and then docket entry 9 was an amended answer. And then I entered my order saying, you know what, Watershed is out. That's not the right party. It's the city. And my order said exactly what you said. City, you should file an answer on behalf of the city by date X, and that's not in there. And so what are the consequences of that? And I'll look at it. And if there's case law that says a failure to answer upon direction of the court means in all circumstances that the petitioners win, then that's like your summary judgment. It'd just be default judgment, and there you go. So you've made that argument, and I got it.
And our further argument is if you find that an answer was not filed, that respondents should not be allowed to present any presentation today as a result of not filing an answer, because they're admitting everything in the petition, including the prayer for relief. So that's where I am on that. I don't know if you need to get.
Nope. When it's Ms. Hackett's turn, what I'm going to do, unless if you've got 92 arguments, I may partway through stop because it'll be hard for me and Ms. Hackett to keep track. But she's going to have her thoughts about what I'll call your first argument, which is default judgment, and then we'll keep going.
Okay. My other, before I get started, I wanted to add.
You keep saying before you get started. We're underway.
I'm sorry. I mean, before I read my statement, the account summary, because I'm going to be referring to that was presented, I'm not sure if the court has the entire account summary. When I looked, I thought it was part of the transcript, but then when I looked at the transcript I got, it was only the cover letter to the account summary. The underlying documents were not a part of the transcript. So I was trying to make sure you have that before I start talking.
Well, you should talk about what you think is in the record. I can rely only on what was transmitted from the board below. If I'm looking at it and I think, gosh, there's something missing, I will coordinate with you and with Ms. Hackett to say, I think I didn't get the whole record. This account summary I can't find. And maybe you actually didn't tender it the right way and it's not in the record. But you were able to talk about it. Maybe you did tender it, it is in the record and it didn't get to me. I'm not saying I don't have it. I don't have it in front of me. I did a little summary, so I've got some bills and dates and all that. But I can't say yes or no, I've got this document you're talking about or that it was in the record. But I am very comfortable reaching out to both sides to say, I feel like I didn't get the whole record. And we don't need to come back to court on that. We can just via email. And if worst case scenario, I'll get everyone on the phone saying, let's talk through this. Shouldn't I have this account summary? It may be that I don't know that it's so essential, but you may educate me on that.
Yeah, and that's not a document we presented. That was a document that was given to us by a respondent at the appeals hearing.
Okay.
I would like to ask a question, if I could, through you to respondent, was whether the account summary not being included in the transcript, was that inadvertent or?
So I need you to present your situation, and I'll engage Ms. Hackett when it's the city's turn, and that's one of the things I'm going to ask about.
Your Honor, between the months of October 2022 and January 2023, we were billed a total of $12,087.06. In response, we filed an adjustment request with documentation from a licensed plumber that there were no leaks on our property and that our water meter wasn't reading water consumption correctly and was therefore defective. The request included a description of how the plumber determined that the meter was defective. We are a two-person household. We do not have a pool, we do not have a jacuzzi, we do not have a sprinkler system. There is no evidence in the record before the appeals board that there was a leak on our property that would cause a meter reading of over $12,000 in a 4-month period. In February 2023, our bill decreased miraculously to $87.84 based on a usage level of 5 CCFs. And remained at that level through April 2023. We have not been billed for over 9 CCFs since that time. Your Honor, CCFs is the unit of measurement that the respondent uses to measure water.
I get the same bills you do. Mine are just a little bigger. So I know about those CCFs. And once you get over that little threshold, they really start hitting you hard because then it's the ones to help pay for all the good work they've been doing with the sewage system.
Okay. Watershed Management denied our adjustment request based on incorrect readings from our meter and the fact that our bill in February 2023 decreased to normal levels.
Let me ask you a quick question so I make sure I'm following you. Yeah. You referred to incorrect readings of the meter, and maybe you said on the meter. I want to make sure I understand your allegation. Is your allegation that the meter was showing the wrong number, or the meter showed the right number, but when the meter guy or gal rolls by, they scan it and they were getting the wrong number? Your meter said 7, but when they scanned it, it said 400.
No, yeah, our assertion is that the meter was reading improperly.
Got it. So it was read correctly by the city. The city was saying you used a gazillion CCFs, right, and the meter showed that. Your allegation is the meter was not correctly operating.
Yes, sir.
Okay.
Yes, sir. And I can go through the process that the plumber used to determine that if you'd like.
Only if it's in the record.
Yes, it's in the record.
Okay.
We did a what they call a bucket test, where first you turn off all the water, turn off the water to the house, and if the meter's still running, then you have a leak. Our meter was not still running. When we turned on the spigot, the and had the water go into the meter, into the bucket. We ran a few gallons in there and the meter was spinning like crazy. And the plumber called me over and looked at this. It's not supposed to spin like this. And I said, no wonder you have these huge bills. So,
is it in the record? And so just tell me if it's, don't answer the question other than is it in the record or not? When the plumber stopped the hose, did the meter stop spinning crazily or was it constantly spinning crazily? And I want to know if it's in the record. I don't want to know what the plumber told you. It's what you think is in the record. Because I'm trying to stay virgin here and rely only on what's in the record. And if you don't know, guess what? I've got the record and I promise I'll pour over that because that plumber is, he's your cleanup hitter.
I don't recall whether that specific statement was in there, but I do know.
I want to know what his answer was. Just, you don't recall whether it's in the record. Like I said, I will look for it.
Okay. Okay. Watershed management. Okay, increase the normal levels. Okay, I'll read that again. Watershed management denied our adjustment request based on incorrect readings from our meter and the fact that our bill in February 2023 decreased to quote unquote normal levels. Watershed never inspected the meter for accuracy. In the denial of the adjustment request, respondent notified us that if we find a leak and repair it, it may qualify us for a adjustment. We appealed that denial on June 20. We have appealed that, and it was heard on June 26, 2023, before the appeals board. Your Honor, the official code of Georgia, annotated Title 5, Chapter 3, Sections 1 through 21, governs the court's review of the respondent's appeals board decision. OCGA 5-3-582 provides that the court is not to accept findings of fact and credibility that are clearly erroneous. OCGA sections 5-3-5A4 requires the court to determine if respondent's denial of our appeal is supported by sufficient evidence. We contend that the denial of the appeal fails to satisfy either code provision. Watershed's appeals board denied our appeal despite the fact that we presented uncontroverted evidence that the meter was not correctly reading water usage between October 22nd and January 2023. Not October 22nd, I misspoke. October 2022 and January 2023. When asked, Watershed failed and refused to provide an explanation for the high bills in a situation where we live alone, had no leaks, did not have a pool, jacuzzi, or sprinkler system. Respondent at the hearing before the appeals board, it was brought out that a respondent has a practice of placing what's called a data tracker on accounts that show elevated water usage. This allows the respondent to pull data from the meter and track any leaks. Watershed did not put a data tracker on our account. Although they were asked why this was not done in our case, Watershed did not provide an explanation.
Was there, if you know, any evidence presented at the hearing before the board about the time frame in which Watershed might put a tracker on? I need to ask that better. Do you need to have had funky readings for 6 months before a tracker goes on? Because this was only 4 months. Now, added up to a lot of money. That's not my point. It's just that it was only 4 months. And if was there any evidence or testimony about, sure, we've got data trackers, but we don't go out to that property until we see month 6 of extraordinary readings?
No, that was not in the record. In fact, this information, this testimony came from questioning by a member of the appeals board to Watershed.
Okay.
Because I didn't know what data tracker, I never heard that before.
Right.
But they did say, I think it was the board member that was saying, where there's elevated levels of water usage, you guys do this to try to find out what's going on.
Right. Okay. But that discussion, as best you recall, it didn't morph into, yep, but we don't do that until there've been 6 months of funny readings, or we only do it when the customer calls, or it's just the Watershed acknowledged, yes, we have this technology which we sometimes deploy.
Yes, they acknowledge that they have the technology, and when asked why did you use it on this account with these readings, there was no answer given. I believe Mr. McCreary said, oh, it's within their discretion.
Okay.
Your Honor, there is no evidence of any of our neighbors or members of the public reporting signs of a leak on our property. Watershed employees come to our property once a month to do a remote read of the meter. There is no evidence that any of these employees reported seeing signs of a leak on our property to Watershed. How that works, Your Honor, is the or a technician from Watershed drives down the street and I don't know, they do something and they don't get out of the car. They read the meter from some sort of radio frequency or something like that. So they don't have to get out and actually look at the meter. And there being no evidence of any reports of a leak on our property by anybody, neighbors, members of the public, I think is significant because if you have a $12,000 leak, you can't hide that. You know, you're gonna have a soaked yard, you're gonna have water running to your neighbor's yard or whatever.
Is it in the record the size of your property?
I don't think so.
Okay.
No, it's not. That's not in the record. Size, no.
But it is in the record that you have no irrigation system.
Yes.
In other words, there wouldn't be a pipe way in your backyard that feeds a sprinkler way in the backyard behind some shrubbery that you couldn't see and wouldn't know that it's running because it's obstructed from view.
No. So, evidence was presented to us at the beginning of the hearing, including respondents' internal notes regarding our account as well as meter usage. That is the account summary I was talking about. That was presented to us when we came up to speak at the podium. Presented to us, I think by, I'm not sure if it was by Watershed or by board. It was on the lectern when we walked up. We were not given an opportunity to review the evidence in the account summary before the hearing ended, and therefore could not address issues raised by that evidence. The decision denying our appeal should be set aside for several reasons. First, it is not supported by sufficient evidence. We presented uncontroverted evidence that our meter was not reading water usage correctly during the time of the high water usage readings. Second, respondent did not inspect our meter for accuracy at any time prior to the appeals hearing. Instead, respondent relied on the fact that the meter was reading water usage as proof that the meter was working. However, the fact that a meter works does not equate to it working accurately. At no time did respondents specifically say that the meter was measuring water usage accurately during the period of the high water bills. Your Honor, I equate this to a situation where possibly you go to a gas station, pump gas. You're gonna put, let's say, 15 gallons in your car. Normally costs you about $45. And you look at the pump and it says $2,000. And the gas station says to you, well, you gotta pay us $2,000 without checking the pump to make sure it's working properly, and it's obvious that it's not. That's the situation that I think that we're in. Let's see. A third reason is member Maltese, which is appeals board member Maltese, based her decision to deny the appeal on the basis that the city checked its equipment and its equipment was operating properly, and that the appeals board could not account for why the meter readings were so high. The evidence does not support member Maltese's statement. As stated before, there was uncontroverted evidence that our meter was defective. Watershed admitted that they never inspected our meter for accuracy. Member Maltese's statement that the high usage readings could not be explained ignores our uncontroverted evidence that the meter was defective. Fourth, Member Maltese and Appeals Board Chairman Clifford Ice stated that
The chairman of the board, his name is Ice.
last name is Ice, yes, Your Honor.
All right.
Clifford Ice stated that because we did not make any repairs, the appeals board could not adjust our bill. This is a bogus standard, Your Honor, because it only allows a bill adjustment where the customer has a leak, has it repaired, and then the bill decreases thereafter. Under this standard, a customer with a defective meter could never have their bill adjusted. Fifth, the appeals board spent a great deal of time speculating on whether we could possibly have a leak, and no time on the issue of whether our meter was defective. Conclusion, Your Honor, the appeals board's denial of our appeal was simply a predetermined rubber stamp of the prior adjustment request denial, which, like the appeals denial, was not supported by sufficient evidence. We seek this court to sustain our appeal, reduce the erroneous bills between October 2022 and January 2023 to reflect our average water usage between February and April 2023, when the meter returned to normal. We also seek a refund or credit for all overpayments by us for the October 2022 through January 2023 bills that exceed our post-February average water usage. At this point, I'm going to say, when we got our first bill in September, it was 153 something. It's like 153 and some change. I think 12 cents.
12 cents.
Right.
Why do you call that your first bill? Meaning you had that's when you moved back in?
That's when we moved back in.
Okay.
And the funny thing about that bill, thinking back on it, we didn't have it before the appeals board, is that was our first bill, but we didn't move back into the house till like the middle of September. So that was right around the time of meter reading, and our renters moved out at the end of August. So unless they used $153 worth of water in 2 weeks, but we're not arguing that because we don't have any evidence one way or the other on that. But we continued to pay that $153.12.
Okay.
All the way through our April bill. Even though we got a temporary payment letter from respondents saying we didn't have to pay anything until this was resolved, I didn't want to take a chance of owing something. So I continued to pay what I paid the first month up to then. Then in May, that's when I started paying what the current bill, whatever the current rate bill was for that month. Thank you, y'all.
You're welcome. Ms. Williams, is there anything you want to add to your husband's very helpful presentation?
No, thank you.
Okay, well, I want to thank, he's got more to say.
I'm thinking, should I do something in my brief? Should I bring it up or just let you read it in the brief? I'll just let you read it.
Okay, well, I want to thank both of you for being here and your thoughtful approach to this. This is my first appeal from the WSAB. It is not my first pro se appeal. What I have much more often are people who are appealing the denial of their unemployment benefits. And those sometimes, they're sort of heartbreaking because it's someone who's not working anymore and isn't getting unemployment, but usually they're denied because they were properly fired. And if you get fired from a job, you may not qualify if you were caught stealing or this or that. And you all have given a very thoughtful presentation, and that's refreshing because sometimes someone comes in and says, I hate my boss and I should get unemployment benefits. Like, you know, that's just the standard isn't how evil you thought your boss was. It was, are you working again? And why were you separated from the company? And you have reasons to be really, really frustrated with what happened. And you are frustrated, but you've persisted, but in a very reasonable way. I want to thank you for that because you could have come in here saying, Andre Dickens is a bad man, and he's not a bad man, and he didn't decide whether you pay your bill or not, and neither did any of these good folks. They're doing their jobs, and I appreciate you making this easier to manage. Judges get nervous when they see pro se on one side, because sometimes it means sovereign citizen or something, and you come in like, I put my own blood on this document, so it is sealed, and I'm a Moorish citizen, and if you use my name, I'm going to put a lien on your house. And I appreciate that you all are saying, look, this is a mistake and it needs to be fixed, and you're persistent, and good for you for being persistent and figuring out the way to navigate it, because some folks give up, and you haven't. And whatever my ruling is, know that I admire your persistence, but your thoughtful persistence. It hasn't been at Ms. Hackett, Mr. Peck was in there and he was giving us the evil eye, and it's because that's not what this is about.
And Your Honor, I just want to say one other thing. I don't know, $12,000 might not be a lot to some people, but we're both retired, so that's a ton of money to us.
$12,000 is a lot of money. Unless your name is Spencer Strider or Acuna, $12,000 is a lot of money. You aren't here over, if this were $100, I probably would have started with, Mr. Williams, really? How much of your, how do you value your free time? Probably more than $100 worth of all that you've done. So I don't come into this thinking, why are we here for a small amount? And with that, Ms. Hackett, I would like to turn to you, and I want you to cover everything and anything you want to cover, but I'm going to ask you to start with your understanding of what the municipal code sections are that I ought to be relying on that deal with appeals from either the board, and if there aren't specific ones, appeals from city decision makers, because I need to pin what I do to that. And I'll rely on OCGA Title V, Chapter 3 that governs appeals in general. But I'm flying a little blind because the city ordinances, as you know better than anyone in the room, you can't pluck them out of Westlaw.
Right.
And I don't mean you need to have certified copies. That's not the test.
Actually, Your Honor.
Perfect. That's even better.
Yes.
And that's the one part of evidence that I am going to admit. It's just because then city ordinances change all the time as the city council is doing what it does. And I needed Ms. Hackett to let me know what she believed the ordinances were that govern how appeals work and standard of review and all that. Insofar as the statutes say anything like that. So come on up. Yes, ma'am. Thank you.
You're welcome. So, Your Honor, again, I will start by referring to the city code that is applicable here. But before I do that, I did want to address what was indicated about the city's following of the answer.
Sure.
The record, and as you mentioned, it's difficult when you have pro se litigants. Initially, the city filed a response or filed an answer on August 21st, 2023, where we did file a response on behalf of the city of Atlanta. Upon closer review of the petition, we noticed that the city was not named. So we filed another answer for the city Department of Watershed Management and the Water and Sewer Board. So the city actually filed two answers. So if we were to be technical in terms of their petition, they did not lodge any allegations against the city. It was against watershed management. So if we were to rely upon the testimony of Mr. Williams, I would be asking for a motion to dismiss, because there was nothing, there were no specific allegations against the city of Atlanta at all contained in Mr. and Mrs. Williams' complaint. So if the court is gonna, but we were going to go ahead and move forward, because the city's position is that the board's decision should stand and affirm. But if we want to get on a technicality about the procedural defect, there are no allegations whatsoever about the city of Atlanta in that petition. So while the order mentions to file another answer, we have two answers that have already been filed. One, again, that mentions just the city of Atlanta, which was the initial one, and then an amended one that mentions both the Department of Watershed Management and the Water and Sewer Appeals Board. By contrast, there's again nothing that the Williams have suggested that the city of Atlanta has done wrong. And so when the court dismissed, based on our motions, the Water and Sewer Board and the Department of Watershed Management, there's no allegations remaining against the city of Atlanta, and therefore we would ask the court to dismiss the petition that they initially lodged, which is why there was not another answer filed, because there were no allegations against us. As a procedural matter, that would be our initial request, that the court dismiss the petition of the Williamses, because there are no parties. There's no allegations against the city whatsoever.
Tell me what, I've got your two, don't panic, Williamses, I'm not gonna do that, but it's a fair counterpoint. But I'll tell you, the thrust of the legislature's amendment to the whole Appellate Procedures Act is that judges ought not to dismiss appeals on misnomers, technicalities like that. And I didn't hear Ms. Hackett saying, you better do it. It's just, hey, goose gander. If you're gonna fuss about X, you should fuss about the reverse as well. But here is my question, and your points are all well taken, Ms. Hackett. I've got the city's initial answer, which was in August, and then the amended answer. Without diving through them, they actually have the very same style of the case. It's not that the initial answer was filed by the city of Atlanta, meaning as style of case. You just mirrored the style of the case that the petitioners, which you should. So it was two city entities, the department as well as the board. And we've cleared up through your input that really it's just the city that should be sued, and sue is the wrong word, that the appellant should be, or the appellee. But tell me what changed in the amended complaint?
If you look at the very first paragraph, Your Honor, where it says City of Atlanta's answer to plaintiff's complaint, it says, come now, defendant, City of Atlanta.
Okay.
And if you look at the second one, it changed it where I entered by special appearance on behalf of the board.
I got it. Okay. Thank you.
So if that request is not granted, my motion to dismiss, I think that was denied. But I just wanted to raise that as the counter argument that the city filed basically two answers. The initial one, again, was the City of Atlanta. And once we realized that the pleading was not done properly, we said that the boards should be dismissed and the department, which Your Honor did grant.
Yep.
So moving forward to the court's inquiry, is the relevant section of the municipal code is section Article 2, where it talks about water and sewer billing and adjustment proceedings. And if we can put it on the screen, or I know everyone has a paper copy, but we can show it as well.
Sure. So this is section 154-28?
That's correct, Your Honor.
Okay. Well, we've got 28, 27, 29, we've got a bunch of them.
We're on page 3 of 6.
You're on page 3 of 6. Okay, got it. And if you want to share screen, Mr. Peck, you're free to do that. You all should have the same rights, meaning technological rights, to share screens.
And while he's doing that, Your Honor, I want to point out that when a customer is appealing their bills, whether it's for 1 month, 2 month, 3 month, or 4 months, which is the case here, the burden of proof is not upon the city to speculate and figure out why your water bill was as high as it is. Even though there was a lot of speculation, as Your Honor will see in the record, whether or not they had a pool, whether or not it was an intermittent leak. I could even speculate that maybe it was because there was some new construction being done during that time period. So there's a lot of different reasons why their water bill may have skyrocketed during that 4-month period. But that's not for the board to determine. It's for the consumer to come in and prove why their bill should be adjusted. And they failed to do that, Your Honor. There are basically, if you look at 154-28, there are 4 different ways that the board can grant an adjustment. Is if there's a billing error, which is 0.1, they can determine whether or not there's a fee credit, which was not the case here. They can determine whether a leak credit should be granted. And that's where we spent a lot of time on 3 and 4. 4 is the meter leak. So the first inquiry the board discussed is, in the department before it got to the board, was there any errors in the billing? And there were not. The second.
And so we're clear, meaning the math was correct.
That's correct.
If the meter said that the Williams is used 143 CCF, the math would be you owe $5,000.
That's correct.
And so that's not a billing error. That doesn't mean there wasn't a mistake. If the meter's broken or there's a leak, but the leak is caused by something the city did, there may be other adjustments that could be made, but we just don't ground it on billing error because 122 CCFs actually translates into a $3,000 water bill.
Right.
Okay.
And so if there was, and there have been cases where there have been billing errors, this was not present. And if you look in the record, you will see the bills and the math adds up. So there's no billing error.
Right.
So then we go to the leak credit. And I will point out in the record, Your Honor, that there was no leak. And I think the Williams has acknowledged that there was no leak. So when we had, and we did have an inspection, Your Honor, and you will see that in the record. The question was posed, did Mr. Bibbs perform the inspection? And he said, no, I did not. There was never, and you can see in the record that there was an actual inspection done. So there's a department, there's someone else who came out to the property and was able to make a determination to the 4th point that there was no meter leak and the meter was not defective. So there was an inspection done. And I will point to the specific parts of the record so Your Honor will see that. So based on that, the board made a determination that there was no adjustment that they could issue because it did not fall within the criteria in order to grant an adjustment.
So what is the mechanism? Let's say that what the person who did do the inspection from the department, what that person concluded was the meter is broken. It's not leaking, but it is not working correctly. He did a bucket test or whatever it was, and it is clear the meter's not moving. I turn on this hose and I do 5 gallons, and the meter said you just sent 100 gallons through the system, and it's not physically possible in that window of time for 100 gallons to have gone through. So the meter's broken. Which of these 4, or that's just too bad for the customer?
You're right, Your Honor. If we're talking about, again, if we're talking about consumer side leaks versus city side leaks, once it goes through and it becomes a consumer side, then the consumer is tasked with trying to figure out why or what they did during that 4-month period. And as I mentioned, without speculating, it could be construction, like if you're building something that was not there prior during that 4-month period, that could have caused it. The board member said, hey, maybe it was an intermittent leak. That could have caused it. Whatever the cause is, that's on the consumer to figure out. Not for the city. The city is not going into the location. They're not going into the homes. That's not our responsibility to figure out why you're using an inordinate amount of water during that 4-month period.
Okay.
But when they do come out, and you'll see, and I want to show you how we can tell that there is not a city side leak. And so if you turn to page 75 in the record, What will typically happen, and we can show it on the screen as well, Your Honor. You'll see the usage details. And I did want to also address just really quickly that the petitioners mentioned that you did not have the packet as part of the record, and it is included. It starts at page 67.
The packet meaning things like the account summary.
Everything, right, the account summary.
That was my recollection. I couldn't from the top of my head say, here was what was in there, but I knew that there was a record, as in a transcript, and then there were some documents. So the account summary is part of what we'll call the addendum to the transcript.
That's correct.
Okay.
So it's not solely just the transcript.
Okay.
That was provided. So on page 75. Your Honor, you see what is the usage details for this account. It has the property address, 69 2nd Avenue Southeast. And then if you go to the read code, and they say remote, and then they say actual. If there was a problem with the meter, it would say estimate, as opposed to, because it would not be able to properly read the meter.
Well, that's a problem with the meter, one where they can't read it remotely or actually. But my question was, it must come up. I mean, things break. And so someone has a meter that isn't working. It's just that, and so the inspector comes out and says, this meter is not working. Which of the 4 bases could the commissioner use to say, dang, we need to fix this?
Well,
because it's not a leak. The meter is not leaking, but it's not working.
Well, that's my point, Your Honor. In order for that to occur, for the meter not to work, it would either stop reading altogether. If the meter on our side wasn't working, you wouldn't get a read. If the meter wasn't working altogether, if there was some type of blockage or stop it, it would say estimate. If the meter wasn't working, the usage details, if you go over to the usage details, it wouldn't add up. This signals to everyone, even though they did go out to confirm it, that it was working properly. We do have cases where adjustments are granted, and you will see that where it says the read code, it will say the things that I'm indicating. This indicates that there is no problem whatsoever on the city side. And so if you look at the code, when they talk about city side versus consumer side, when we have situations or when they do the inspection, if there was an error or if they noticed some type of leak when they came out, then they would have noted it and tried to address the problem.
But why is the universe of options limited to leak or no water is flowing, like opposite of leak? What if the meter's not working well and it's not reading correctly? It's sending you a signal. And so if you're driving by in the truck, you're happy. But the evidence in the record is the meter is not correctly measuring the flow through the meter. Which of the adjustments would one rely on? It's almost as if you've built, not you personally, but the city built a system where that's deemed to be an impossibility. In my recollection, not making it part of the record, is that when the city first rolled out these Neptune meters, this is long ago, when I first became a judge, we had a bunch of class action suits where large groups of people were suing the city because the Neptune meters didn't work. They would give these crazy readings. So if that's what one finds the record shows, that the meter was defective, there's no possible relief because it's not a billing error. The math adds up. It's not a fee. I don't even know what a fee credit is, but that's not what this would be. It's not a leak because no one's saying leak. And it wasn't a meter leak, which sounds like we'll call it the city side of the pipes. It's none of the above, but it ain't the customer's fault because that's one out of every 1,000 Neptune meters is defective. I mean, one out of every 10,000 Ford Escorts didn't work. These things happen.
And Your Honor, that's a point. However, all of those meters have been replaced. We have not had that situation to occur that you're mentioning.
Until now.
And based on the read code and the usage code, it's speculative. We can speculate.
Okay.
Right?
So your pushback is I want to be very clear. I'm not linking the original rollout of the Neptune meters to this. That was long ago and they were replaced and those class action suits got dismissed, which courts loved.
And this meter was inspected. And if the meter had been defective, it would have been replaced, which is what we do. So it's not a matter of us wanting to charge customers $20,000 for a 4-month period. But at the same time, Your Honor, it's not the city's responsibility to go into the property owner's home to figure out why your meter, why your usage is more than normal.
I fully appreciate that.
Yeah.
I have lived through that experience where my bills were up and there was an inspection and the person said, it's not on the city side of things. And lo and behold, unlike the Williamses, unfortunately, I do have an irrigation system and some pipe in the backyard and the ground was really squishy there and we fixed it. And
you're right. And I would like to add, even if they come onto the property and they see that there's something going on, like they might see that they're doing new construction, that's not going to be a part of what they put in the report,
right,
because his job is just to see if the meter is working.
Understood. Okay.
And so based upon the documents that we have in front of us, so 75, and Mr. Bibbs, and we mentioned Mr. Bibbs earlier, I would just say, Mr. Bibbs was not the person who went out to do the meter. So when they engaged in this speculation about, well, it's a pool or this or that, he wasn't there. But if the person in Department of Watershed Management had been there, he might have speculated again because of the new construction. So there's a lot we can do that, but that's not what the board was charged to do. The board's responsibility under the code, and the only authority they have under the code, is to make an adjustment based on those 4 things. And because everything was working on the city's side, the inspection did not reveal. And if you go to, and I can show you on page where we have the notepad information, Your Honor, on February the 22nd of 2023, and it's on page 73 in the record.
Tell me what notepad information, I'll read what's on the screen, but put that in context. What is notepad information?
Notepad information is the system that the Department of Watershed Management uses to document every incident and everything that happens with respect to a particular property. And if you notice from the top, which starts June 12th of 2023, anytime there's any type of incident involved in this property, the note is entered, right? And they put down, and if you see, there's different columns and how they address it. And if you see, and that's the last entry on this particular one, where it says appeals hearing at the top. But if you go downward, it's in reverse order. It starts on page 74, I believe. No, I meant in the reverse order.
Yep, right.
Where we have August 12th, 2022 as being the first entry. And it kind of even tells you what happened. And it'll say work orders. There's notations when the Williamses may have called and made a complaint. There's notations where, so if we start from September 8th, for instance, on 2022, it will denote the time. It says at 2:02 p.m. It says consumer called to check if account was active in his name. So they put the notes in as things are occurring.
So I'm curious, if you scroll back up to that February entry that had been highlighted, February 22, 8:13 in the morning, that's when you contend the inspection was done?
At 8:13 in the morning, yes.
On February 22, which would be a month after the last challenged bill. So no inspection of the meter during the 4 months of the peculiar bills. I just want to make sure I'm reading the records correctly.
That's when the actual physical inspection was done.
Right. So whoever it was, and there's a work order and we can figure all that. It wasn't Mr. Bibbs, but whoever inspected it did so at a point when the bills were back in the $80+ range and not in the multi hundreds or thousands of dollar range.
Well, actually, no, Your Honor. The bills went back to normal in January.
Okay.
So the bills had already
either way, my point is that inspection was looking at the meter that would not be registering correctly or incorrectly the level of usage that brings us all together.
All I can say, Your Honor, is I know that the physical inspection was done in February.
Okay.
And what I can also say is that no one did any repairs.
Okay.
Whether it was the city or the customer, the evidence in the file shows that there was no repairs. So there is another mechanism, Your Honor, where adjustments are granted when consumers find or customers find a leak. If they find a leak, they submit their bill from their plumber or whomever it is and say, hey, look, we discovered a leak. And that gives the board the ability to make adjustments.
I didn't know that. So my situation, I did have someone fix my pipe out in the backyard. I could have then sent the bills that let me know there's an issue saying, and here's what I fixed. Here's the plumber.
Right.
Dang, what's the deadline for doing that?
Yeah.
12 months, Your Honor.
12 months.
All right. Well, you learn something new every day.
And I think that's a problem that a lot of the customers do have, is they don't understand that if they do find a leak on their side, and they acknowledge, and I think that was one of the issues that was raised, another customers, or when customers find a leak and maybe they are have a pool or whatever it is, if they fix the leak, the board has the ability to make adjustments. But when you say, I have no leak, and we say, well, we don't have a leak, so.
Right. It's a standoff and the burden is on the customer.
That's correct, Your Honor. So, and so if we go back again, Your Honor, I just wanted to point that out, that, I think I pointed out the bills here. Yeah, Your Honor, again, and I think I made that point, but I'll reiterate. If you look again at the meter reads, the meter wasn't replaced. So if the meter was defective, it would still be giving these, I don't remember the word they used, but these high bills. If the meter was defective, if there was something wrong with the meter, it wouldn't be reading. So the only thing that changed is during this 4 month period, something on the customer side was going on. Because the city has not done anything. The city has not changed the meter, replaced the meter, fixed the meter. There was no repairs done to the meter. So again, logically, what was the consumer or customer doing in their home during that 4 month period? And it coincided with the customer moving back in. They didn't have a problem with the meter when it was being rented. The problem occurred when they decided to move back into their home. And now, whatever happened or whatever they were doing in their home is no longer taking place. And again, they have the burden to show that there was a leak, that they fixed the leak, or there was something happening on their side. Because on our end, the meter was working, it's still working, it's still reading properly. There's no error messages, there's no estimate reads. And all the numbers add up. And so for that basis, Your Honor, I would argue and submit that the city is requesting that the decision of the Water and Sewer Board be affirmed. And that the petitioners have not shown that there was an error in law and in the fact, they're defining the fact, as you started off saying, this is not a de novo proceeding. And so they found, based on hearing the testimony of the petitioners and after hearing the testimony from the Department of Watershed Management, that none of the criteria to establish an adjustment was met.
Got it. Thank you. Anything else?
No, Your Honor.
All right. I appreciate the citations to the record as well. That'll help me focus my review. If you don't mind stopping the screen share now, I'm going to pivot back to Mr. Williams as the person the parties that brought us here to see if you've got anything you want to say in rebuttal, in closing. You don't have to at all. You have very eloquently expressed the concerns that you and Ms. Williams have, but I want to give you that opportunity.
Yes, I would like to offer rebuttal, Your Honor. I'm gonna go back to the beginning of respondent's presentation about the answer being filed by the city. And that they could make a motion to dismiss, which they did, which you rejected.
Well, I am likely not, given my understanding of the recent revisions to the appellate statutes, to dismiss your petition because you maybe didn't name the party quite right. No one was left confused as to what you were challenging. And so it's supposed to be substance over form. That is the thrust of these amendments. And the substance of your challenge was city and anyone inside the city government. You've wronged us by billing us more than we should have been billed. No one's confused about what your concerns are. So I'll still want to double check, but I really wanted you not to jump out of your seat saying, what, dismissal? Where's this coming from?
Yeah. Your Honor, I want to reiterate or make clear that petitioners went down that road regarding the answer because based on respondents' representation to Monica Niles, that the August, I think it's 21st, answer was filed on behalf of the Department of Watershed Management. Now that may have been because there was confusion because our original petition named Department of Watershed Management in the appeals board. But
when you say original petition, though, I'm not aware that you ever amended it. So your only petition,
right, our petition,
it named watershed, it named a department, and it named the board. It didn't.
Yeah. Yes. And but like I said, the representation to Monica Niles or to the court was that initial answer was filed on behalf of the Department of Watershed Management. If that's the case, that means City of Atlanta has not filed an answer. Okay.
Well, but if City of Atlanta wasn't sued, City of Atlanta doesn't need to file an answer.
Absolutely, and I agree with that.
Okay.
But then I follow that up with your order dismissing their motion to dismiss dated December 18th, where you specifically in the last sentence gave respondents until January 18th to file an answer, which they did not do. So my position is, or our position is, if the first answer was not on behalf of the City of Atlanta, but on behalf of Watershed Management, then you were given an opportunity, 30 days to file an answer on behalf of the City of Atlanta. Once City of Atlanta is added to the case as in this decision, and they failed to file an answer, I don't think they can go back and rely on the first answer that they said was not filed on behalf of the City of Atlanta.
Okay, I got you.
Okay, all right. Responded, one thing that they mentioned several times is that the burden is on us, on petitioners at the appeals hearing. We were never told that. We were never told that the burden was on us to prove anything. We were just told that this is an informal hearing. I think they said it's non-adversarial. I believe they said that, but they said it's not a trial. And we want to hear from you, and then we're going to hear from Watershed Management. nothing was said about who had burdens for what at the hearing. Also, respondent mentions this February 22nd, 2023 inspection. As noted by Your Honor, that inspection took place after the February 14th reading of $87.84. So basically it has no relevance to what happened in the 4-month period. Number two, at the hearing, it was asserted by Watershed Management that someone came out to our property and checked to see if there was a leak on the city side, but specifically said the meter was not inspected. It's a difference between coming out to check to see if there's a leak on our side and coming out and testing the meter to see if it's measuring accurately, which they did not do. Also, respondent mentioned the speculation at the hearing about an intermittent leak, which was described to us by Mr. McQuarrie. Did I pronounce his name? I think it's McQuarrie or McCary. I can't remember.
Who is that?
He was a representative of Watershed Management at the hearing.
Okay.
Let me make sure I read his name correctly. I don't want to butcher his name.
Well, there's no court reporter, so it's okay.
Oh, it doesn't matter. Okay.
Right.
So anyway, an intermittent leak was explained as a basically minor leak where a flapper in the toilet or a washer is loose and it repairs itself. It kind of goes back. And petitioners did raise at the hearing an intermittent leak would not explain $12,000. An intermittent leak would not result in a $12,000 bill. So I just wanted to bring that up. And again, just like at the hearing, respondent is continuing to equate a meter working with a meter working properly. There's two totally different things. The meter may be working and measuring water as it goes through. That doesn't mean it's measuring at the correct rate. And if you have, to me, it seems like if you have a complaint from a citizen with supporting documentation that the meter is not correctly measuring water usage, not that it's not working and running when water goes through, it seems to me the city has an obligation, if they're dealing in good faith with the customer, to come out, run an inspection on the meter, test it as to whether it's reading the water accurately. Do the bucket test if they want to come out, turn the water on and see if the thing's spinning like crazy. They didn't do that. So that put us petitioners in a bad position. Also, I wanted to mention about, and I may have already, the account summary, which Respondents Council referred to several times in the presentation. I want to reiterate that that was presented to us, that was on the lectern when we walked up. We never had a chance to review it, so we didn't have a chance to ask any questions of the board or watershed management about any of those entries or anything like that. In fact, there's an entry in there that I think on November 9th, pursuant to a telephone call from me to.
So are you sharing with me something that's in the record now?
Yes, it's in the record.
The
It's
fact
in
that,
the document.
okay,
It's in the account summary in the notes.
okay,
November 9th, that after I told them I didn't have any leaks and this and that a meter investigation was initiated by or requested internally at Watershed Management, but the evidence is that nobody ever actually went out and inspected the meter. We did not even know about that entry at the time of the hearing. You know, we found out basically later through a news report from Fox 5 reporter Data File that this was in the records that she subpoenaed. Let's see here. I also want to just mention or bring to your attention, it's in the brief, but that the respondents didn't be hung up on leaks. That, you know, if a leak happens here under these circumstances, you can get relief. Our situation is not dealing with a leak in the pipes or in the meter. It's something totally different. And I think that that was a problem we had at the appeals hearing, is that the focus was so much on trying to establish whether we had a leak and whether we had it repaired, despite the fact that that was not our contention, nor was the evidence supporting that. There was no evidence of any leak. We never argued that we had repaired. Although, as I mentioned at the hearing, if we did have a leak and I would tell you, and that we had it repaired, because then you would give me an adjustment. But I was going to be honest and say, no, we did not have a leak.
I mean, other than the evidence that the city has relied on, which is the meter showed all this water going through. And so that is circumstantial evidence of a leak. I hear you saying, you say there's no leak, but there's all this water going through and then it stops. And so that's a leak that gets fixed. That is what I have to wrestle with, because I can't climb in their heads. 3 members of the board denied your request. And so it may well be, and I don't get to second guess them, and they said, look, the most reasonable explanation of this is you all moved in, something you did in moving in caused a leak, the leak got fixed, and the bills are normal again. I mean, you have a different explanation for it, which is the meter was working, but not working properly. And I get that also, but it's kind of hard to disprove the negative, or to prove the negative. How do you prove that there's no leak when the meter is saying there's water going through? And you say, hey, there's no leak, but if the leak is draining into some aquifer below your house, there's not going to be the kind of evidence you could say the ground is soggy, or I hear pipes running, or something like that. I'm playing devil's advocate here, but part of your reaction is it's ridiculous that they say there's no leak, because I told them there's no leak, but the meter is telling them there's a leak, or you just left a fire hose on in the backyard, and we know that's not what happened. So there's what we would call circumstantial evidence that there was a leak, because if the meter were broken, how would the meter fix itself? I'm just playing the devil's advocate. And to Ms. Hackett's point, it's not ever the city's burden, as this discussion starts, to say, here's what the problem was. That's the property owner, the customer, who needs to show, here's what was going on. And you had plumbers come in and say no leak, and I did the bucket test. So I'm not saying that you provided no theory whatsoever, but when you say this isn't a leak, I've told them it's not a leak, that may not be what the board concluded. And there is evidence they could point to, which is, look, at the meter was supposedly broken and then it magically fixed itself. So that's something that I'll need to wrestle with.
Yes, and Your Honor, when you look at the transcript, you will see that the appeals board did not say that we had a leak. In fact, they ruled against us because we did not have a leak. That's in my brief. Okay, all right. Also, to your point that the meter showed what may have been a leak, I tended to challenge that somewhat, in that city says there's no leak on their side. We presented documentation there's no leak on our side. What's left? It's not reading the water. It's not that water is going through. It's not properly reading the amount of water.
Right.
I mean, under the respondents' thinking, which is not that there was a leak, but that we used $12,000 worth of water in 4 months. We would have had to have a giveaway of water that we advertised around the neighborhood, saying, come get free water, 24 hours a day, 7 days a week, to get $12,000. We're not that stupid. We're not going to do something like that. So anyway, Your Honor, and as to the meter, like I said, and I may have said this before, respondent's position is that the meter was not defective because it was running when water was going through, which does not address our position and our evidence which they never explored. And that the usage dropped. Well, the usage didn't drop. The rate that the meter was reading the usage at went back to normal. We can't explain why. We're not experts. All we do is we're just citizens. We get water from the city. They're the experts. They should come out there and test it and find out why it's doing this. I think that for some reason, well, I shouldn't say that because it's not in the record. Did I say that on the book?
Okay, then let's stay away from it.
Yeah, it was my opinion on why they pursuing this, but I'm not gonna do that. So other than that, Your Honor, I don't have anything else. Oh, I do have one question that you can pose to, because I guess I have to ask you, then you ask respondent to counsel. I'm looking here at, I just want to make sure I understand. Am I looking at the right page? Oh, 154.27 says the appeals board shall consist of 7 persons. Why do we only have 5?
So that, I mean, I'm not gonna ask Ms. Hackett that. I'll look at that.
I just
Who knows?
saw 7 on here. And I said, there's only 5. Okay.
Your Honor,
Yes, ma'am.
okay, I do.
Very briefly.
I do have, hopefully I can make it brief. I do have, a quick couple of responses because it is in the record and is still continuing to make, comments about, what could happen. If you look at the record at page, 28, Mr. Bibbs did indicate that the consumer or the customer had made repairs at the property. And I did want to point out, and I do have a photograph, if I could share, of what the property looked like right around the time where, what's the first photo?
John, I want to object to the photos. They were not presented to the appeals board.
Where did you?
So on the record, it indicates to the board that there were repairs being made at the property. So that is in the record.
Someone said there were repairs being
Mr.
made.
Bibbs, yes.
Mr. Bibbs said that in his testimony, but these photos weren't anything presented to the board?
The photos themselves were not presented
Okay,
to the board.
then let's not look at the photos.
But I will, okay, so the repairs occurred during this 4-month period.
Okay, and that, Mr. Bibbs testified to that. Where did you say in the record?
It's at page 28.
Okay.
He said our interpretation of the invoice was that there were repairs made at the property. And, but then that the customer testified that there were no repairs being made at the property. So that's kind of where, and then he further states consumer size repairs. So when we talk about repairs, they may not have fixed the meter, but things were going on at the property that were observed. But again, the city's and the board's responsibility is just to address these 4 items.
No, I understand. There are very good policy, legal liability reasons why folks from Watershed ought not to be tromping around inspecting the property to see, well, wait, is there a leak that would explain this? And so I don't see that as the issue here, is why didn't the city figure out if there was a leak on the customer side of the meter? That should never, ever be the role of Watershed. Someone could get shot, so.
Right, exactly. And then the next, what page on that on the record? When Mr. McCreary testified, I'm sorry, on page 34 of the record, Your Honor. 34. That's not 34. Sorry, we just had it. I just want to be at the director on it. Oh, here it is. It's on page 32 of the record. And Mr. McCreary starts his testimony at line 24. And Mr. McCreary is the person that goes out to inspect the meter. He's the senior inspector for the city. And what he said is we call these positive displacement meters. That's the type of meters we have installed now. And he said, and if they go bad, they would stop counting. And it actually will result in to the advantage of the customer, because you wouldn't get a read at all. So, and then, so that did not happen in this particular case. So if the meter went bad, and that's what I wanted just to reiterate, the customer would not be billed. It would just stop working. So, it goes on page 33. The meter was delivering a remote read, meaning that the water flowed through the meter and it counted the consumption. So, and the consumption was going through the meter at that time. So the person who came out for the customer was a plumber, and the only thing he did was a bucket test. He did a 5-gallon bucket test. And that is not a definitive test that a meter is defective. So again, the burden was not on the city. The city's equipment was working properly. There were things going on at the customer's property at the time that they had this increase. And they said, if it's not a leak, then what is it? We would argue usage.
Right.
And that's all I have, Your Honor.
All right. We are about done. Ms. Williams, there was something you wanted to add. And I'm happy to hear from you as long as what you wanted to share is something that's in the record, as opposed to, wait, I can explain the work that was going on at the house. If that was something that you or Mr. Williams shared with the board below, then you're welcome to tell me where it was in the record or sort of summarize it. But if it's simply, I've got this additional information, that's not something that I should consider now. I know that may seem artificial, but if it wasn't something you shared with the board, I can't base my decision on anything more than what the board had.
I don't know if it's specifically listed in the record per se,
Okay.
but well,
You don't think it's in the record?
I don't think it's in the record.
Okay.
You know, if you can dismiss it or throw it out, but
No, I don't actually want to dismiss or throw anything out. I just don't want to hear it if it wasn't in the record. And I know that's frustrating. It may seem artificial, but you might tell me, yeah, there was construction, but it was all on the roof and we turned the water off when they were doing so that it would, but that would have been a thing to share with the board. So the board could say, well, let's rule out the construction work that was going on because they actually had to shut the water off in order to do the work. Then that could not explain increased usage because you had someone come in saying under oath, I'm the one who did the construction and I was installing desert plants. And so the last thing I wanted was water because it would be bad for the desert plants. But that's not where we are. Mr. Williams, you and Ms. Williams want to file that brief.
Yes.
You'd like me to consider it.
Yes.
What I'd like you to do is e-file it. That'll make sure it gets to Ms. Hackett and anyone else on the city's legal team. And that'll get it to me as well, because it will go into the docket. So however you e-file before, you clearly know how to do it because I was able to pull your petition up again this morning. So e-file that. And then what I'd like you to do, Ms. Hackett, is to give it a read sometime this week and let me know. And do you have an email for one of the Williamses?
Yes, I do, Your Honor.
Great. If you could send an email to Ms. Niles and one of the Williamses with either no need to respond or I would like to respond and I'd like 10, 14 days. You have up to 2 weeks. Ask for as much as you want, up to 2 weeks. You're free to do that. But I'm also open to the notion that you appreciate what they filed, but you don't feel the need to file anything in response. I just don't want to prevent you from responding if there are points you want to make.
And you would want me to put that in an email if there is no need to respond?
No, I want you to, whatever your answer is. So what I'm asking is by close of business Friday, email to Ms. Niles and whatever contact you've got for the Williamses saying the city is resting on its presentation or the city is going to be responding to the Williams brief and we will respond by date X, which would be well, I'll give you the date. It would be by April 5th, because that's 2 weeks from Friday.
Thank you,
Okay.
Your Honor.
You're very welcome.
One more thing?
Sure, if it's not
Sure.
getting back into the meter or the bills.
Just that Respondents Council mentioned that Mr. I think Mr. Bibbs or one of the McQuarrie said that they thought we had a leak. She cites, page 28 at the top.
I promise I'm gonna reread all the pages.
I think that that's a typo. If you listen to the audio, which is the official one, he said that,
Well, so the official one, so you know, is the transcript that's been created. So if you think that there is an error in the transcript, that's something else that we'll need to litigate. I don't mean as in you bring another suit, but the official record for me to consider is what the court reporter created through the transcript. If you think that that transcript should be amended because you've listened to the recording and what Mr. McCrary said is it was not a leak, and what it says in the transcript was it was a leak, then you should share that segment of the audio with Ms. Hackett. And if she hears it the same way as you, then just let me know. And I'll make sure when I read the transcript, I put the word not in there. So if you think it's a fundamental rewrite that would occur if the transcript accurately tracked the audio, then please bring that to Ms. Hackett's attention. I'm sure she'll listen to it. If she disagrees, I'll referee it. I have ultimate say as to what ought to be in the transcript. But I'm just letting you know that the way records go up on appeal is it's the the paper record. I know it's all digital, but it would be the transcript and not press play on the audio.
yes, and I was looking for something at the time. Page 29 is where Mr. McQuarrie said that looking at the receipt that respondents mentioned, he would assume that the plumber probably just probed the yard, but I don't think he probably made any repairs because it probably would have been a cost under invoice or something. So basically, he did say he didn't think there were any repairs made, and I think, Your Honor, in the summary report, there is a invoice provided to us by HomeServe. HomeServe took over service warranty. I don't know if you have a warranty on your. City used to offer a discount on warranties for the sewer and water line, and we got one. And basically, that first plumber came out, checked the meter, checked everything, said you don't have any leaks, and left. Didn't give us any documentation we could use, so that's why we had to call the second person out. And then we asked service warranty, HomeServe, could you send us the receipt that he provided? They sent us this invoice.
This is something that's in the record?
Yes.
Okay.
And under the problem, I think what the board was getting caught up on was it said product name, exterior service line. But under repair code, there's no repair code.
Okay.
So there's no repair was made, it would have been a code there. And it would be to our advantage to say that we had a leak in a repair made. So we wouldn't hide that.
Okay.
Okay.
I don't think anyone's hiding anything. I appreciate it.
Thank you.
You're very welcome. I want to thank both sides for being here on time, having thought through this and being organized in your presentations. And I will take this under advisement, go through the record again, now benefiting from arguments from both sides. And I will also hold off on doing anything in terms of entering an order until Ms. Hackett has a chance to, you need to e-file today. So don't leave if the way you have to e-file is by going to the clerk's office,
Yes,
please don't leave the courthouse till you've e-filed your brief.
Okay.
Because then that's given Ms. Hackett the maximum 2.5 days to read through it and then get that email to you and Ms. Niles saying, we're good, we're not going to submit anything, or we will be submitting and she'll probably pick April 5, but we'll get something to you by that date.
Okay.
And then I won't work on it till then because she's entitled, if she wants to say counterpoint, because you've got point, and she can, in writing, say counterpoint. She's already done it, I believe, verbally, just like you did, but it needs to be fair to both sides.
Yes.
Your Honor, can I ask for a copy of it if he has it now?
Do I have any extra copies?
If not, that's fine, I can wait, but,
Well, I will.
oh, you do have an extra?
Well, she wrote on it. It's not.
If you're gonna go e-file it right now,
That's
we're
fine, I
good.
can wait.
yeah, so that way it'll be in her inbox, she can print it, double side, single side, however she wants to. And it won't have writing on it that the city is bad or whatever people wrote on it.
Thank you.
All right, Williams's, anything else?
I didn't hear you, Your Honor.
Anything else?
No, Your Honor.
Okay, thank you for your time. Ms. Hackett, anything else on behalf of the city?
No, Your Honor,
Thank you all for your time.
and thank you for yours, Your Honor.
All right,
Thank you.
you are welcome.